this issue of accessible versus inaccessible data, which we've talked about under Rule 26, when you have what's called basically inaccessible data, which would be, in large part, are going to be emergency backup tapes. That's really what the litigation about inaccessible data is. That's the Cyberlaw case, as you're all familiar with. Then you get into a cost-shifting analysis, and that was one of the issues that UBS Warburg was arguing about with the plaintiff in that case, that they didn't believe they wanted her, Ms. Cyberlaw, to spend hundreds of thousands of her own dollars to basically go through the backup tapes to try to retrieve email that UBS said had been destroyed. Judge Scheinlein laid out a cost-shifting analysis, which is actually now written into, if you look at the advisory committee notes to the Rule 26 amendments, they actually adopted it as well. And you'll see on the issue of trying to retrieve data or try to retrieve information from emergency backup tapes, you'll walk through this analysis on cost shifting. As Judge Scheinlein pointed out in the Cyberlaw decision, really the first two are the most important, and that's really where the courts have focused their attention in terms of actually determining whether or not the requesting party or the producing party should have to actually bear the cost of producing information in a case. As a guy who practices in this area, I think one of my favorite things is spending a lot of time with people who try to pronounce the name Cyberlaw, because I think you can hear it pronounced about 8 different ways. And one of these days, maybe I'll meet Ms. Cyberlaw, who's made enough money in that settlement that she's probably living very comfortably somewhere very far away now. But if I ever see her, I'll find out how to pronounce her name. Sanctions are huge. Just 2 pieces of flavor on sanctions. Again, this was something which was all over the Wall Street Journal and the New York Times, so I would imagine you all probably came across this. The Morgan Stanley case involving Coleman Holdings. There was a willful and gross abuse of the discovery obligations by Morgan Stanley. That was a $1.4 billion judgment that was entered against Morgan Stanley. It was not predicated entirely upon the issue of the spoliation and the issue of the electronically stored information hijinks that Morgan Stanley got up to, but it was a very, very big part of that decision. The aforementioned Z case, I can't pronounce her name, $29 million verdict after UBS actually was found for destroying emails and backup tapes and not properly participating in electronic discovery of electronically stored information. Just a few more slides as we turn for home, and again, any questions, I'd be happy to tackle them. An interesting tangent for you all to consider as you look in the issue of discovery and electronic discovery relates to discovery from experts. This is actually an area which is there's not a great deal of case law yet in this area, but it's growing, and it's growing very much in step with the growth in the volume of case law in the area of electronic discovery. As you probably have come across already in your civil procedure class, under the federal rules, there is an affirmative obligation to turn over to your adversary all information considered by an expert informing the expert's opinion. In the arena of IP litigation, patent, copyright, and trademark, where I practice, invariably there's going to be an expert involved in the adjudication of the merits of the dispute. And so you spend a lot of time seeking and taking discovery from experts. This case from Virginia, which Trigon is a case which predates the amendments in 2006 to the federal rules relating to electronically stored information. But at the same time, there were sanctions that were imposed there, including an adverse inference regarding the expert's testimony as a result of the fact that the government in that case had failed to actually preserve or adequately preserve its correspondence with its expert in the area of electronic communications. Right now, what you get into just from a practice standpoint as it relates to experts, you are very much directly involved now in actually seeking electronically stored information from your adversary's experts. You want metadata for the drafts of their expert reports. who looked at it, who accessed it, who wrote it, who put different pieces of text into the actual reports themselves. Can you find a way, for example, to show that your opposing law firm, actually they authored the expert report themselves and they just sent it off to their expert who just stamped their name on it and got paid $25,000 and handed the report in? If you can find that, it's going to be fantastic for you. And so, and it will successfully get an expert out of a case. So there's a big piece of work that goes into that. What's involved in e-discovery? This is very much a 30,000-foot view, but certainly something as younger lawyers, as an older lawyer, I deal with every day. And just this is what, if you practice in this arena, you'll find yourself spending time doing. Gathering, searching, filtering, and producing large volumes of relevant information. Going through, basically starting, the simplest thing to start with would be an email system and going all the way through network systems and servers, and then to get into backups. I say email systems, let me just tell you very briefly from, again, kind of in practice how email works. Initially, meaning in the 2000 to 2004 time period, more often than not, courts were forcing litigants to actually go through what amounted to tens of millions of emails. It was a very, very burdensome process, very time intensive, very, very costly, and it was something which I think most everyone acknowledged just really didn't work. So what typically happens now, and I say typically because it's not actually provided for under the federal rules and it takes agreement between the parties, but typically what happens will be you and your adversary will agree upon a set of search terms. You'll agree to 25 or 50 or 75 particularly relevant terms that you will actually run against your body of 10 million emails. And then you will then produce to your adversary only those emails that actually come up off those search terms. And that's actually very much how practice progresses today and how email is tackled. Moving forward, part of going through electronic discovery, as any younger lawyer will find out, unfortunately, is creating privilege logs, is actually holding documents back on the basis of the fact that they contain either attorney work product or their attorney-client communications, or they're otherwise privileged. I've not yet had a chance to do a priest-penitent privilege, but I'm looking forward to that day, and hopefully, I'll keep it interesting. As it stands right now, in a case that we had worked on for an investment bank, we went through 4 million emails, and we had a privilege log, which I think the last time I looked at it 4 years ago was about 1,000 pages long, as an Excel spreadsheet, single-spaced. And so ultimately, where the rule seems to be going, or where the case law seems to be going, is to remove the burden of actually having to create such a ridiculously large privilege log that's really not useful for anyone. All that's really being done is just effectively just adhering to your obligations under the federal rules. The suggestion is to try to go now to simply grouping documents and putting them into a privilege log and tackling it that way. So that's something which you'll see changing a little bit.